Okay, go ahead.
Senate Judiciary is in session. We are going to start with HB 315.
318.
I should have put my glasses on. 318. I didn't put them on. Senator Carson is introducing the bill.
Thank you very much, Mr. Chairman. Good afternoon, members of the Senate Judiciary Committee. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Auburn, Londonderry, and Hudson. And I have for your consideration this afternoon House Bill 318, relative to magistrates, bail commissioners, and the standards applicable to and the administration of bail and making appropriations. I wanted noted for the record that there was no one from the House to introduce this bill. Thank you very much.
Thank you, Senator.
Good afternoon, Chairwoman Carson and members of the committee. My name is Alan Oldenburg, and I'm currently the police chief for the city of Manchester, and I'm here to testify in favor of HB 318. Let me first thank the many senators and representatives who have worked diligently on this bill over the past several months. Please know that your efforts are appreciated. Departments and communities across the state continue to experience problems with the current law. There are still countless cases where individuals continue to reoffend while out on bail, not just in Manchester, but across the state. The most recent example I will give you happened in the city of Nashua, where an offender was arrested on February 8th, charged with resisting arrest. He was released. Rearrested again on February 21st, arrested for criminal trespass and breach of bail. Again released. Arrested again on March 18th. Arrested for 3 counts of resisting arrest, breach of bail, drug possession. Again released. Rearrested again on March 26th. Arrested for resisting arrest, 2 counts of criminal threatening, criminal mischief, criminal threatening with a deadly weapon, felon in possession, 2 counts of breach of bail, released. Arrested again on April 2nd, arrested for criminal mischief, criminal threatening, released. A warrant was issued on April 19th for burglary and felon in possession, and on April 22nd, the same individual was involved in a vehicle pursuit and subsequent foot pursuit in the city of Franklin, and he was not apprehended. In regards to HB 318, our primary focus is on Section 5, and that we fully support those who are alleged to have committed those 13 most egregious crimes, and that they are to be held and seen before a judge or magistrate the next day. The one concern that we have relative to the language surrounding these felonies is the use of the term substantial evidence. As to my knowledge, this is not a burden of proof standard. I would request that you consider changing this to change it to the preponderance of the evidence. Also, we do have one final concern relative to the effective date of the bill, July of 2025 as it's currently written, over a year from now. I would offer that our communities can't wait. We need action now, and we'd ask that you consider a new effective date for this section of July of 2024. The specific crimes that are in the current bill: homicide, second-degree assault, first-degree assault, felony level domestic, aggravated felonious sexual assault, kidnapping, felony level stalking, trafficking in persons, robbery, possession of controlled drugs, manufacture or distribution of child sex abuse images or computer pornography, and child exploitation. These are serious violent crimes with victims, many of whom were seriously injured, shot, stabbed, or physically assaulted or sexually assaulted. None of these crimes are misdemeanors, they are felonies. In closing, we ask that you move the needle on this legislation, and I thank you for consideration and happy to take any questions, Senator.
Thank you very much for your testimony, Chief. Are there any questions for the committee? Seeing none, thank you very much.
Thank you, Madam Chair. Thank you, Senators.
The chair will call Mayor Ruiz. Good afternoon, Mayor.
Good afternoon. Good afternoon, Chairman Carson, Vice Chairman Gannon, esteemed members of the Senate Judiciary Committee. Thank you for affording me the opportunity to address you today. As Mayor of Manchester, the largest city in the state, I come before you in support of House Bill 318, the bill reform. I recognize the weight of the decisions you face, especially on matters like this, with passionate beliefs on both sides of the issue. I want to take a moment to thank all of the representatives and senators who have worked on this legislation over the course of this term. We appreciate your efforts to find compromise. I come before you today to speak about the need to secure the safety of Manchester and with care and concern for the victims of the heinous offenses this legislation seeks to address. Between January and March of this year, Manchester Police Department has conducted 1,203 arrests. Of those, a significant 25% were individuals out on bail at the time of their new arrest. I held a press conference in March in which I stated the following statistics. Over the past 12 months, Manchester Police Department conducted 4,529 arrests, and in 26% of those cases, the arrestees were out on bail at the time of their new arrest. This data underscores a critical issue. Violent and repeat offenders continue to be released on our streets, putting our citizens at risk. Our police are doing their jobs, and we have formed incredible partnerships with other local, county, state, and federal enforcement officers. Just yesterday in Manchester, our police, in concert with the Hillsborough County Sheriff's Office, conducted a joint enforcement day, which resulted in more than 100 motor vehicle stops and over a dozen arrests. Our law enforcement officials are performing heroically every single day. We as elected officials have an obligation to address their concerns, especially as it pertains to bail reform. This is not just a Manchester issue, though. A strong, vibrant, thriving city benefits the entire state, and safety is critical to this effort. This alarming trend is a clear indication that our community is facing challenges that require a comprehensive and strategic response. As a city, we have a duty to protect our residents, and it is clear that our current system is falling short of meeting this responsibility. Allow me to share a little bit about my personal journey. I've been sober for 14 years. I found recovery because I was sick and tired of being sick and tired. Candidly, becoming involved with the criminal justice system helped divert me into a better path. I took responsibility for my own actions and grew into the person that I am today. This is a testament to the power of accountability. While my experience is not an argument to rely solely on arrests as a solution, it does speak to the importance of enforcement and effective behavioral change. I urge the Senate Judiciary Committee to pass this legislation. We cannot afford to allow individuals charged with serious offenses to be released out onto our streets to reoffend without consequence. There is a balance to be struck here, but public safety is paramount, and we must ensure that individuals are held accountable for their actions. Bail reform is not about depriving individuals of their freedom due to financial constraints. It is not about ability to pay. Rather, it is about holding those who repeatedly violate societal norms and laws accountable for their actions until their cases are adjudicated. It is about keeping repeat dangerous offenders behind bars. These offenders are reoffending time again and putting a large strain on our police force and our citizens. For Manchester, the passage of this bill and other reforms is imperative because the safety of our citizens is non-negotiable. It is an opportunity to prioritize safety and accountability, ensuring that our communities are protected and justice is served. We have a duty to govern and find compromise. Please take this opportunity to enact meaningful change. Thank you once again for your time, your efforts, and for your consideration of this legislation.
Thank you, Mr. Mayor, for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you all.
The chair will call Representative Rhodes. Representative, are you here to walk us through the bill?
Thank you, Madam Chairwoman. I am, and I apologize. We were in executive session. And if it is okay with you, Madam Chairwoman, Representative Wheeler was on the committee to work with this. And if it would be okay with you, if he could join me just to make sure I hit all the points that we're going to be discussing, if that's okay with you.
Representative Wheeler, would you like to come up? Just make sure before you speak, identify yourself for the record.
Yep, absolutely. Thank you, Madam Chairwoman. I'm Representative Jennifer Rhodes. I represent Chester County District 17, which is Winchester, Richmond, Swansea, Troy, and Fitzwilliam.
Thank you, Madam Chair. Members of the Senate Judiciary Committee, always good to be here. I'm Representative Jonah O'Ryan Wheeler from Peterborough, New Hampshire.
So, Madam Chairwoman, as you are aware, this is 5 pages a lot of words. And over the summer, we had a subcommittee to work on. We tried to address all of the concerns that have been brought to us from all of the stakeholders that are involved. And one of the reoccurring themes that we heard was that there is a list of crimes where it was felt that that person should not basically be able to go in front of a bail commissioner, that should go in front of a judge. And what was brought to us was the reoccurring theme that a person is innocent until they are proven guilty. So how are we going to hold somebody in jail if it was, say, a weekend, if they got arrested on a Friday night and now there's not a court open until Monday? So the committee addressed this with the magistrate system, which is pretty much the whole page 3 and 4 throughout this. And also if a person has been rearrested while they're on bail. And another problem that we've heard is, for whatever reason, New Hampshire seems to be way back in time, and we do not have a system in New Hampshire that lets another officer or lets another bail commissioner know if a person is on bail in the first place. So the very first thing that was important to understand is we did add money for a system, basically a bail system, to know if a person was already on bail or not. That would be the absolute first thing. And then if a person is arrested, they will be able to have the ability to go in front of a magistrate within 24 hours. And the magistrates are going to be employees of the court that the justices are going to appoint. The justices are going to actually be the ones that are going to be in charge of the magistrate system and appointing those. Let me think. There was questions about, we raised the amount of money for bail commissioners. We've heard over and over again that not only are the bail commissioners not getting paid, but the expense for them with the rising costs of everything is involved today. So we did make an appropriation to raise the amount of money that a bail commissioner will receive for the services. Everybody should get paid for services rendered, regardless of the job that they do. And we made it be where those fees are going to be collected by the court. So the bail commissioners are going to get paid. And additionally, I want to say we raised it to $50, but I think that might have been changed again. And I apologize, Madam Chairwoman. There were some changes that were made, and after the Finance Committee had our bill. If a person is found to be indigent, then the court will have their discretion whether or not they want to put this person on a payment plan to have those fees recovered, or it is up to the court to decide if a person is indigent and have those fees not be paid. Additionally, we put another mechanism in here for monitoring, a monitoring device, and that also is going to be at for the court to be able to decide if a person has to be the one to be financially responsible for the monitoring device. Is there anything that I'm forgetting off the top of my head that you're thinking, Representative Wheeler?
No, I think this is Representative Wheeler. I think Representative Rhodes hit it essentially right on the nail. I think the bail commissioner's fee was $50, and the Finance Division 1 added money to be given to them for the training as well. We thought that was important. The Finance Division 1 committee, and I can speak to this as somebody who followed that very closely, and Chairman Leishman is out of state on important business right now, so unfortunately he couldn't be here. But I expect that he'll send you an email shortly with what his experience was with this bill. The magistrates was originally supposed to be 15, as I'm sure you're all aware. The Finance Committee made it 10. I think that's a solid compromise that the House was able to come up with. We tried to make sure that there wasn't too little magistrates per county. 15 was essentially one magistrate for every county, with a couple of counties being bundled up based on how urban they were. Yep, the electronic monitoring system. The raise is consistent with a Senate bill that was passed on to our committee in this session. So I think, as all of you know, there's some overall agreement with where we need to go, and we worked very hard on this compromise and very diligently, and we look forward to continuing to work with
Can I
you
ask some
to
quick
get
questions at
passed.
this point? Really short.
Yes.
Just on, I have a lot of bail bondsman friends. So are they not going to collect the fee anymore? At like when they bring them in at night, they usually charge them on the credit cards. Is that system over?
Thank you for the question, Senator. So what we had heard in the committee was that the overall bail commissioners that we actually have left have not been being paid at all. So we did make it where it is going to be collected and charged by the court. So my understanding, and I would ask you to please forgive me, I have not had the opportunity to review this after the finance committee had it, but I do believe it is going to be up to the courts to
Good, thank you.
in one collection, like a month. And additionally, Madam Chairwoman, all of the bills that we have received in the committee, from this committee, have all been addressed within this particular package. Of course, we've heard about people being rearrested while already out on bail. We've heard about a person being rearrested for the same crime, multiple times. All of those offenses have been addressed in here, and that is what I was originally saying, which is basically on page 4, which I believe was Senate Bill 248.
Okay. Are there any questions? Okay, I know that I have a lot of questions and I don't want to belabor you. I'm just looking at the magisterial system right now. This is brand new.
Yes.
And I'm looking here at the first page on line 5, and the paragraph through page 9. It says qualifications, but there's no qualifications here. So you're basically saying the Chief Justice and the Chief Justice of the Superior Court and Administrative Judge of the Circuit Court shall appoint at least 10 magistrates subject to appropriation by the legislature. And then it says they serve at locations, but there is no qualifications listed. So who are the individuals who are going to be chosen as magistrates? What are their backgrounds? What do you think that they need to be in order to serve in this role? Did perhaps House Finance take those qualifications out?
If I may, I know House Finance dealt with that issue. I don't want to speak for House Finance, but I know that we want these people to be qualified. If we're going to be paying them the amount of money that we are going to be paying them, then I think that's important. There was an assumption that these people would be lawyers or people who have experience with the judicial system.
Okay, because I'm looking at this and they're going to be conducting bail hearings. They're going to issue warrants, an other process for arrest, search warrants, administer oaths and affirmations. So I think that there needs to be some real qualifications here because these are very serious duties. I just don't know if you had them in an original version. I don't know if I have. Usually Matthew's really good about giving me the different versions. So I'll have to go through and look at if there were even qualifications because you have to have those in there.
Madam Chairman, I believe Aaron with the judicial system might be able to, the judicial council, no, I think that one is Aaron, the other one is Kate. I think
Okay.
there's so many lobbyists, but I think she worked very diligently with the finance committee and she'd be able to answer that question more
Okay.
apt than I. I was
All
looking
right.
around.
Other questions? Senator Abbas, did you have your hand up?
It's not quite a qualification, but if you look at the authority of the magistrate, which on lines 11 to 22 on the first page, same page 25 and 26 says of those responsibilities, virtually all of them except for one, you won't be able to perform unless you're licensed to practice law. So that's just saying what it is. It's not that's the only qualification I thought.
Senator, I appreciate your comments. because this is new, I think everything needs to be very clear. So that's my point. If you want this to be attorneys or retired attorneys, then that should be stated. They must be in good standing with the New Hampshire Bar in order to do this. So, again, just to make things very, very clear, because this is brand new. You don't want to be making assumptions, so.
And it doesn't say good standing, it just says.
No, but I mean, I think we're gonna have, this might be something we need to deal with. So, okay. Are there any further questions? Okay, seeing none. Thank you both very much.
Thank you, Senator Carson.
Okay, next we'll call Aaron Cregan.
Good afternoon, Madam Chair, members of the committee. I'm Erin Cregan. I'm the General Counsel for the Judicial Branch. I appreciate very much the opportunity to work with the Policy Committee on this bill. They spoke to many people and did a lot of work to accommodate some of the concerns. Of course, as always, the Judicial Branch is neutral on the overall policy objective. It's up to the legislature to determine how to proceed in this area. And we have the ability to implement this plan, but we also have the ability to implement other designs if there are negotiations that need to occur. I'm happy to talk through any questions about judicial administration and how things currently work now, if that's helpful. But I can also go through some of the features of the bill that have significance for the judiciary. One of the features that was very, very important, as I understand it, to the prime sponsors was having the 24-hour determination. This is a big change from how things currently occur in New Hampshire. Right now, there is no night or weekend court. Some states, some cities have that. We do not. So there are determinations by bail commissioners over the weekend and at nights, but court is not open. I think that the policy intention that the sponsors had was they wanted someone with more qualifications than a bail commissioner making this determination, but they did not feel as though we needed to go all the way to opening the courts on the weekends, for example. I do believe that I saw previous versions in committee that had suggested qualifications, and I think that they were that a certain number should have police experience, a certain number should have defense experience. And if I'm remembering correctly, I think some of those were taken out because there was concern about finding qualified people and not wanting to be too hemmed into a specific quorum that a certain number needed to have specific types of experience. Realistically, we always, it can always be a challenge to find people with lots of criminal justice experience in the state. So my understanding of that change was that it was intended to create more flexibility, but you're right, that there were many proposed qualifications here that were removed before this final version went forward. Having a magistrate system is something that it's up to the legislature to decide, but potentially there is a gain. Right now, many of these functions which are done on the first page, the duties are being done by judges who are the most expensive labor that you have in the judicial system. And a magistrate, although there is an idea to have competitive compensation that draws good applicants, it's certainly not equivalent to a judge. Judges are highly compensated. So potentially there's some efficiency there, but the linchpin of making that 24-hour system work in the vision, I understand it, of the policy committee is having those magistrates. If you're questioning whether to have magistrates or the 24-hour requirement, I would say the two are conjoined, and that's something to kind of be addressed jointly if you're thinking of making any changes. One of the changes that was made in finance, which I think was a helpful change that all parties agreed on, was to move some of the electronic monitoring responsibilities over to the counties. Right now, I believe 4 counties, and I think Ms. Horgan may be here, already have electronic monitoring programs. Some states have a pretrial division in their court system. We do not. We don't have a pretrial division. We don't have any personnel that would administer that type of system, and the counties have excellent programs. So Ms. Horgan worked with the Finance Committee to make a change to rework some of that electronic monitoring language so that I think it will now work for the counties, and they'll have the ability to implement it in a way that also realizes the policy vision of the prime sponsors. Another feature that was added into this package in finance was the existence of a judicial training coordinator. Originally, this was a bill sponsored by Representative Kutab, which is a very perceptive and good idea. We currently don't have a dedicated person who handles training within the judicial branch. Unfortunately, the final language that made it in had mandatory training. As many members of the committee may know, even when the branch is seeking resources for training, we run into a minor constitutional issue with mandatory training language. So even with instances where we wanted, for example, our court security officers to have certifications, we've worked with the Senate, for example, on SB 130 to put that in permissive language so that we can still get that training, but we don't have an example where, for example, a court security officer refuses to do the training. We try to enforce it, they sue us, and they win because the statute is ruled to be unconstitutional. So it's something that I think can be solved very easily by reverting to the original language that the prime sponsor introduced her bill in, which is permissive language, but that is something that would potentially be a roadblock to implementation that the judicial branch would hope to change. I've talked for a little bit, so I'm happy to stop and take questions.
Thank you very much for your testimony, Ms. Cregan. Are there any questions, Senator Abbas?
Thank you, Madam Chair. Thank you for taking my question. And to the extent you can answer this, so if you have this magistrate system in place and a person gets arrested, and just say for like drunk driving, something, so the person's presumably impaired. They have this hearing before a magistrate. They don't have counsel present. Now it says on page 6, lines 11 to 15, that's when they can, basically they're being held, but they can then request a subsequent hearing to basically have that, whatever bail conditions reviewed. I guess my concern is what happened at the hearing with the magistrate, is it going to be a de novo hearing? Or is it going to, meaning like it's whatever happened to that, those statements going to be used against them? I guess for me, I'm concerned is, are they going to start saying things I would probably not want them to say at the magistrate hearing, because it could be in the middle of the night. But at the same time, I understand it's just getting to the next.
Thank you for the question. My understanding is that the intention with the magistrate system is to essentially have a highly qualified salaried bail commissioner. So right now, when someone's arrested, they're taken to a jail, potentially a prison. A bail commissioner comes usually and meets them there, usually without counsel, usually while they are still inebriated or under the influence of drugs, if that's the case with the crime, and tries to make an assessment and ask them essential questions to determine whether they should be released. Some people decline to meet with the bail commissioner. They don't want them to see the condition that they're in, or they don't want to make that argument. They say, I'll wait, I'll go in front of a judge in a few days or tomorrow. But that is something that currently happens. So I think what you're envisioning is it would be a very similar process, but instead of it being a person who is essentially a volunteer, our bail commissioners are public servants. They're not very highly compensated. They volunteer really to do this service for the state. Someone who is receiving much more training and is a salaried person and has, therefore in the judgment of the House Policy Committee, more competency to determine these very serious crimes. But the intention, as I understood it, was also to retain bail commissioners for anything other than those 13 crimes.
I might have overlooked this, but would that magistrate hearing be recorded?
It's not my expectation that it would be. It's not specifically provided for, and it would be a challenge to do that at many of the jails and other facilities that currently occurs at.
Thank you.
Okay, are there any further questions? Ms. Cregan, I had asked you earlier about an updated fiscal note because I noticed this one was from February and it has since made some substantive changes as well as going through House Finance. So if you could supply this committee with an updated fiscal note, we'll be able to send fiscal a complete package.
Yes,
so to
ma'am.
say.
I certainly will. And I think generally the costs are expected to be, some of them are already allocated, but it's a little over $1 million to pay the bail commissioner fees. It's about $1.6 million for the magistrates, about $150,000 for the judicial training coordinator. And there's a high startup cost of the electronic bail data system. It's about almost $1 million for the first 2 years, but then it drops down to $290,000 for each subsequent year.
Okay. Are there any further questions? Seeing none, thank you very much, Ms. Cregan. I have two folks that have signed up together, Travis Cushman and Sean Eldridge. Would you like to come up together? Okay, terrific. Well, we have three. Okay. You don't want to testify? Okay. They got it. Okay, great. Please just make sure before each of you testify that you identify yourselves for the record.
Thank you, Madam Chair and Senators. My name is Travis Cushman. I'm the Superintendent of the Merrimack County Department of Corrections, and I'm here today on behalf of the Association of Counties Superintendent Affiliate. We, as a group, had two major concerns with the bill as introduced. One being the magistrates and the requirement to be seen by a magistrate within 24 hours of arrest. We have concerns over the availability for the magistrates, and if one is not available, where would be the next step, and where would be the liability lie if we held somebody without having the bail set within 24 hours, or if we release them back into the community? It just doesn't leave the county correctional facility much of a place to go with that 24-hour period. And I know that we have a strain right now with bail commissioners, and having bail commissioners come to the facility sometimes can be a challenge as well. So I just think with the introduction of at least 10 new magistrates, that it might just be another additional challenge for us. I know the other big piece for the county and the affiliate would be that only 4 of the counties currently have electronic monitoring. We're lucky enough that Merrimack County is one of them. So it wouldn't be as much of a lift for our county. Our pretrial services division is a separate division from the corrections division. They are a county entity, but not under the umbrella of corrections. But some of the other smaller counties, or even the larger counties that don't have it, it would be a significant cost. And I know Superintendent Eldridge was going to speak to that cost.
Good afternoon, Madam Chair, Senators. Superintendent Sean Eldridge from Carroll County Department of Corrections, speaking on behalf of the Association of Counties. And as you all know, there's 10 counties in the state of New Hampshire. Each county has superintendents responsible for care, custody, and control of the inmate population. Our big concerns, once again, I'm going to piggyback a little bit on what Travis is saying here in regards to costs and availability to magistrates. The other question that we have also in regards to magistrates is, if when they are not available, is there going to be a judge available on a Saturday or a Sunday? And if so, who's going to transport that individual to the courthouse or wherever it need be to be seen or heard? Or is it going to be done electronic? Pretty much, I believe all the facilities now have electronic Zoom systems that we can do hearings through, which again adds more cost. We need more staffing to be handed on the weekends. So a lot of us run with low minimum staff members on the weekends, or minimum staff members in general. My facility, Carroll County, is a very small facility. We have only a total of 32 staff members, and that includes myself. If you take the 4 members of the administration team, all that work Monday through Friday. Now we only have 28 staff members available to break up over a 7-day period, 24 hours a day, because we're a 24-hour operation. Again, and also if we take on the cost of electronic monitoring, who's going to monitor those? We, as the correctional facility, would be responsible to do so, but again, another added cost. I'm going to need more staff, cost of the material. Fortunately, I'm very familiar with electronic monitoring, pretrial and sentenced. I had 20 years with Rockingham County prior to coming to Carroll County, so I'm well aware because Rockingham County budgeted for their own electronic monitoring program. So I'm very aware of how the system works and the added cost on that end. You're looking at it roughly, I believe back then, again, don't quote me 100% with a dollar amount here, but it was roughly $6.30 a day to monitor an inmate. And on average, we were averaging about 22 inmates out on the program at a time. So that's, again, another added cost. And I know there's language in here talking about if individual is indigent, the individual would not be held against them, and they would still be allowed to go out on electronic monitoring. Well, that's an added cost that's going to go back to the taxpayers, excuse me, to the county. So looking at all that, we put in a price of basically what it would cost for all 10 counties to go to this. Added cost for staffing, the monitoring of it, cost of the bracelets. If the individual is indigent, cost of us paying for that service, because it won't be the individual that's on the program who's paying for it. We're looking at $15 million. I know Coos County is much smaller than us, so it's even a bigger concern from them. They, again, have a facility that's a deal with inmate population as well. So again, that's really our big concerns here and also the magistrate's availability.
I just wanted to jump on there. that I think is the trouble with making legislation that affects all the counties because we are so vastly different in size and scale resources. As Sean said, he has 36, I believe 34 total staff members. I have 36 correctional officer vacancies right now. So we're, the lift that it would put or the strain, adding something, we're already set up for it. It would be more of the question for us and how it will affect me. And I think I can speak for everybody. It's just that transportation on the weekends and who's responsible for it. If a Zoom or a video arraignment was not available or a video hearing with the magistrate, I think that would just be a major impact on the operation.
If I may say one final thing. The only other concern that I have, and maybe I overlooked it, and I've looked at this a few times now, and I've gotten up there in age, so glasses are becoming very important for me, so, is the decision in the individual, if it's court ordered for the individual to be put on electronic monitoring. I'm okay with the court recommending electronic monitoring, but at the end of the day, it's the superintendent's decision if the individual or individuals go out on it, because they take on all liability and responsibility. We are not identified like the courts are. So again, level of charge is a big concern to me, because electronic monitoring, and I know, I've, like I said, I've dealt with it directly. I've been out there at midnight, 1 o'clock in the morning on the streets of Rochester, outside of a trap house, because one of my electronic monitors are not doing the right thing in the wrong area, trying to collect these individuals. So there's a lot of liability there, and who is it going to fall back on, and then also who's the individuals that are, what charges they are, what qualifies for them to be on electronic monitoring. A very strict, severe violent charge. Are we okay with putting them on bracelet, or what level? And so maybe I'm overlooking some of that language, and I could be, or maybe this just hasn't come up in discussions, or nobody's given it any thought. That's the only. Again, those have just been my experiences that I've dealt with personally. And it's put a lot of liability back on the superintendent and on the facility.
Okay, thank you very much for your testimony. Are there any questions? Gentlemen, you gave me the cost of 15 million to the counties. Is that collectively?
Collectively.
Okay, and so it would vary, say, between Hillsborough County and co-op?
Absolutely, because of the number of population and number of bookings that they do and how many inmates would be on that program.
Is that 15 million per year?
Yes.
Okay. Okay. All right, thank you. Are there any further questions? Okay, seeing none. Thank you both very much for
Thank you. Allow us to
testifying
speak.
today.
Have a good day.
Yeah, thank you.
Okay, on the chair, we'll call Buzz Chair. Good afternoon.
Good afternoon. Thank you, Madam Chair. My name is Buzz Scher. I'm a law professor at UNH Law. I'm also an elected police commissioner in Portsmouth. My opinions are mine only. They don't reflect the opinions of UNH Law or the Portsmouth Police Commission. I was at all but one of the 3 months worth of hearings that occurred in House Criminal Justice. Just to deal with the most immediate testimony, I find it incredibly unfortunate that at this late moment, we now hear from the two individuals that just testified that there's a $15 million cost. They didn't testify in front of the House committee. They didn't testify in front of House Finance. And so I think they misunderstand what this statute says. The electronic monitoring provisions in this statute are only for people who are being released on a protective order. It's not for every single person. So it's not going to cost $15 million. Each county can contract with an entity if they want. And House Finance thoroughly vetted this, and it's incorrect to say it'll cost $15 million. The individuals need to pay for their monitoring. The numbers we were talking about, we in Stratford County, superintendent at one part, the head of their pretrial services program, said they had 7 people on protective orders. So this is not comprehensive electronic monitoring. So it's not going to cost $15 million. Back to address the availability of the magistrates, the whole point of the magistrate system is that they be available. You know, they can go to the jails. They're just like bail commissioners who can go wherever, to the police department, to the jail, to a court, and it's within 24 hours. They're not going to be arraigning somebody or setting bail on somebody at the moment they're arrested for a DWI and are intoxicated. You know, they'll be held overnight and they'll be seen in the morning. So there's no issue that ever has come up of anyone expressing until today any concern with the availability of magistrates issue. It's just not an issue. The whole point of the magistrates is that they'll be available on Saturday morning, Saturday evening, Sunday morning, Sunday evening, holiday mornings and afternoons. That's why we have 10 magistrates. In terms more broadly of the social service aspect of this, there's another bill that involves that's not joined with this that involves the ICJJC, which I'm not going to articulate what the acronym is for because I keep forgetting it. But that committee has been tasked in the next year with looking at pretrial services programs for those counties who don't have pretrial services, who can't afford them. Right now, like Stratford and Cheshire County have pretrial services because they house a lot of federal inmates and they make a lot of money off of that and they can afford pretrial services. So there's ICJJC is going to look at ways to implement statewide pretrial services. So that's a separate thing that's going on. Just to address things that have come up. In terms of qualifications, I can provide, there was language in here. I don't know where it fell out. My guess is in House Finance. There was language in here that said that the magistrates there were to be a balance in the magistrates, that no more than half had a law enforcement background, no more than half had a background in criminal defense. The expectation is, given the language that was pointed out earlier by Senator Abbott, the expectation is they'll be lawyers because it makes a lot of sense. But I can provide this committee with a more detailed set of qualifications as an amendment if the committee wants that I think will, from what I get, will reflect what the committee is thinking in terms of being a lawyer in good standing, et cetera. That would, I'm more than willing to do that for the committee. What hasn't been pointed out is there are a couple of provisions that that were added specifically that we didn't see in any of the bills coming from the Senate or from others in the House. One provision specifically was on page I think on page 9, lines 19 through 32, that requires that the police department, if somebody's going to be released on bail, that the police department make an effort to notify the victim at least an hour before an individual is going to be released. We felt that was a very important provision that helps victims of crimes. And the protective, that's number one. And number two, the electronic monitoring system was put in place for those who are subject to a protective order to help manage contact between domestic violence victims and their abusers. So that's a feature that hasn't been in any of the other bail bills that we see. The July 1st, 2025 implementation date versus July 1st of this year. I understand the sooner we do this, the better. I'm just not sure the court system can ramp up the magistrate system that quickly. So, perhaps a compromise would be January 1st of 2025 or later in 2024 so that the court system can ramp up the magistrates. They're going to have to hire 10 magistrates and get that organized. I'm trying to I think the last issue is the substantial evidence standard that Chief Aldenberg had some difficulty with. That was a much negotiated item. As I'm sure this committee appreciates, there's everybody involved in this, every stakeholder involved in this who we heard from, had things they wanted in this bill, and every stakeholder got something, and every stakeholder had to make a compromise. I don't like the substantial evidence standard. I want it to stay at clear and convincing evidence. But we appreciated, particularly the Prosecutors Association was very adamant about making the standard something less than clear and convincing because it was particularly hard to meet. As I said, I disagreed with that. Nobody, not even the Prosecutors Association, was looking for a preponderance of the evidence. So that's where the substantial evidence came from. Yes, there are provisions in other aspects of the law where courts talk about substantial evidence, but I think it's as defined in the statute. It's somewhere between a preponderance of the evidence and clear and convincing. Courts will figure that out. There'll be a case that goes up to the New Hampshire Supreme Court that will make it clear what's more clear if it needs to be what substantial evidence is. So I urge this committee. It's very tempting to tinker with this. I get that. But I can't overstate the amount of work that was put into this to get everybody to agree with this. I think it's noteworthy. This committee can appreciate that myself, Chief Aldenberg, I know the Prosecutors Association, the Coalition Against Domestic and Sexual Violence, all are in support of this, and that's an unusual coalition. So I strongly urge the committee to approve this. And as I said, I'm willing to offer to the committee some language for an amendment in terms of qualifications.
Thank you very much for your testimony. Are there any questions, Senator Abbas?
Thank you, Madam Chair, and thank you for taking my question. You brought up the substantial evidence language that's on page 4, line 14. And I understand that there's been other drafts that said clear and convincing evidence, some said preponderance of the evidence, but kind of discussed a similar policy. Do you recall those?
There was no draft that said preponderance of the evidence. This was always a struggle between clear and convincing evidence and substantial evidence, and it was the strong request of the Prosecutors Association that for these particular crimes, not all bail hearings, but for these particular crimes listed, the list of felonies, that there be some relief from the strictness of the clear and convincing standard. As I've said previously, I'd like it to be clear and convincing, but welcome to the land of compromise.
Follow-up?
Thank you. Although I didn't agree with your analysis on the other drafts, my understanding is you have stated on several occasions that anything less than clear and convincing evidence is unconstitutional.
That's my belief.
So if that's the case, how can you support this if it's unconstitutional? If you believe it is?
Again, I think that's going to be the subject of litigation. There's other interpretations of U.S. versus Salerno. There's New Hampshire case law that one could interpret that it's not unconstitutional. It's a compromise that I made from my perspective and that I was willing to support. Not that my support matters all that much in all of this. But you're right, and I have consistently said that. I continue to maintain that position. But the prosecutors were willing to go forward and litigate that issue, and they're confident that they can win that issue. I think that's relatively minor litigation. There's one case that's going to go up to the New Hampshire Supreme Court at some point that'll litigate whether it's unconstitutional to have something less than clear and convincing under the Salerno case. But the whole package was more important to me than standing on the principle I've articulated endlessly. I know to you, Senator.
Just surprised to hear you would support something you didn't find constitutional, but that's fine.
Are there any further questions? Okay, seeing none, thank you very much.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 318? Okay, seeing none, we're going to close the hearing and we are going to be in recess until 3 o'clock. So, okay. And then we'll, okay, you should be able to. Ooh. Okay. The committee will come out of recess. Can I get a motion to go into executive session? Moved by Senator Gannon. Is there a second? Seconded by Senator Chandler. Okay, the first bill that we are going to take up is House Bill 38. I move interim study. Seconded by Senator Gannon. Some of these, they're just not ready for prime time. That more work needs to be done on some of these. So that's why we have a motion of interim study. Is there any further discussion on the motion of interim study? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, move consent. Is there a second moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay. Is there anyone who would like to take this one out? Senator Chandler. Okay. Okay, next, we have House Bill 185. I would like to move interim study, seconded by Senator Gannon. For those of us who have been here for a few terms, we know that this bill keeps coming forward to us. And as always, there is a lot of pushback on this particular bill. I think this bill, each time it gets filed, it gets better. I just don't think it's there yet. I think there's just some more work that needs to be done. And so that's why I have moved interim study. Is there any further discussion on the interim study motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, we have the consent calendar motion moved and seconded. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, and I will take that. Did you have something, Rick? Oh, I thought. Okay. Next, we have House Bill 475. I'd like to move interim study, seconded by Senator Gannon. We've seen this before. I think we saw this maybe last term. Providing testimony, parties in family court proceedings shall have the right to present evidence and testimony. We did have some support for the bill, but we did have people that voiced some concerns. And again, because those concerns have not been answered, so I moved interim study. Is there any further discussion on the interim study motion? Okay. Seeing none, all in favor say aye. Aye. Any opposed?
Move consent.
Senator Whitley moves consent, seconded by Senator Gannon. Okay, is there any further discussion on the consent calendar motion? Okay. Seeing none, all in favor say aye. Aye. Any opposed? Okay, is there anyone who would like to take this one out? Senator Abbas?
I can take that out. Can I ask, for 185, if we can go back to that one? I don't want that one on consent. If I can,
You want to reconsider the consent calendar motion on 185? Why?
I think for that one, I still,
You can always
I
pull
can-
it off consent, Senator.
well, I could do that, but I don't wish to actually support that one. So we can go,
So you want us to have a revote?
if that's okay. I don't mean to cause delays.
Okay, so, pardon?
Finish this bill first.
Yes, he voted in favor of it, and then he's now changed his mind. Pardon? Yeah, we need a motion to reconsider.
Do a motion for reconsideration on,
Okay.
or
Is there a
House Bill
second?
185.
Okay, so,
Thank you.
okay, all in favor of reconsideration, say yes.
Yay.
Opposed? No. I'm sorry. That,
I won't forget that.
I know you won't, but you
I-
can pull it off consent, Senator, and you can
No,
discuss
but
it.
it's the custom we give our, the courtesy. I asked Bill what number we were on, then you called the vote. I actually didn't even say anything for the microphone, to be completely honest.
Okay, all right.
So,
Can we redo that vote and we'll
but
just?
out of a courtesy.
Nope, out of courtesy,
And
it's
I've
just,
done reconsideration.
we had discussed this and I thought you were okay with it and now you've changed your mind. So, okay, so, we're going to, I'm not sure. Yeah, we'll just move reconsideration again. Move reconsideration, please.
Move for reconsideration.
Second, okay, all in favor say aye.
Aye.
Opposed? Okay, so we have a motion of interim study. Is there any further discussion on the interim study motion? Okay, seeing none, all in favor say aye. Aye. Opposed?
Nay.
Okay, and I will take this one to the floor. No, because it goes away, because we didn't, okay. Next we have, let's see, I want to make sure we're going along. We have House Bill 535. I'll move interim study. Seconded by Senator Gannon. This is a bill that's dealing with the appointment of counsel for children. We have already dealt with this issue in this committee. This bill is overly broad and extremely expensive. Our bill was, we worked with the advocates, we narrowly tailored it, and it's going to be less expensive. Yes? Yeah.
May I just ask, where in the process that bill is, just for?
It's in the House.
It's-
I testified it, okay, so it was passed out of policy committee.
Okay.
So,
Thank
okay,
you.
you're welcome. So we have an interim study motion. Is there any further discussion on the interim study motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed?
Consent?
Okay, so we have a motion for consent. Is there a second? Seconded by Senator Gannon. Is there any further discussion on the interim study, on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, I'll take this one out as well. Next, we have House Bill 618, relative to wage garnishment with child support payments. I have an interim study. I'd like to make an interim study motion. Who seconds?
I'll second.
Senator Gannon, okay. We really only had one person testify on this bill.
Yeah.
Senator Whitley, do you have anything?
No, that's exactly what I was going to say. We
Yeah.
just really did not have any testimony on this.
Yeah, other than the prime sponsor. And this is something that the court can already do now. So why is this bill needed? So,
I think it would be a good policy for the court to adopt, mandating under RSA, different story.
mhm. Yeah, I mean, maybe this is something they can adopt through rules, but this, from what I understand, they're already doing this through practice. Most people will sit down and they will discuss what they want to do without doing this, so.
The courts generally make their own standard forms that they want, so this should be no exception, but requiring them to make a standard form,
Mhm.
I think may be kind of outside what we really want to do.
Okay, so we have an interim study motion. Is there any further discussion on the interim study motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, is there a consent calendar motion? Moved by Senator Whitley, second by Senator Chandler. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, Senator Abbas, would you like to take this one out?
Yes.
Okay. Okay. Next, we have House Bill 1006. I'd like to make a motion of ought to pass. Seconded by Senator Gannon. We have an amendment here. It is Amendment 1603S. I'd like to move ought to pass on the amendment so we can have a discussion. Seconded by Senator Gannon. I thought that this was good to go, but Ms. McKinney from New Hampshire Legal Assistance has a concern. So if you'd like to come forward just to tell us what your concern is on this particular amendment.
Microphone.
There you go.
I apologize. I just realized I don't know where my copy of the amendment went, but I will just say, we just feel like this bill in New Hampshire Legal Assistance, our position is that it is an unnecessary bill. There already is a motion that can be filed and a process in place when a party is in contempt of court, including related to a court-ordered parenting plan. And there is a process in place when there's risk of irreparable harm to file an ex parte motion. That has to be heard within 30 days. It can be expedited to 5 days if by the party who it's filed against. So if there is no risk of irreparable harm to the child, the normal court process takes place. This basically, we need those emergency cases where there's a risk of irreparable harm to kids to take priority, and this basically just would make a lot more cases, give a lot more cases essentially priority in terms of that, cutting that line in terms of time. And so we're concerned the impact it will have on the courts and the cases being heard timely. We also,
Ms. McKinney, I'm going to stop you here.
Okay.
Because I see that New Hampshire Legal Assistance opposed the bill, but you folks did not testify at all on this bill, other than just signing in that you were opposed to the bill. So this is not an opportunity for you to talk about how legal assistance doesn't support this legislation. That opportunity has come and gone. We're talking about this amendment.
right. I guess what I was speaking to is I don't think the amendment addresses the concerns, our underlying concerns with the bill. We still have those concerns. That's all.
Okay, thank you.
Yep.
Can I ask a question?
Sure.
So is your main, so I hear you say it's not necessary, but is the main concern that, like, is there a harm that you're suggesting?
I think that the risk is that it will just take longer to hear cases, it will put more pressure on the courts in terms of hearing those cases timely, and I think that's the main risk. We also do have other concerns, but I'll just keep it at that.
Thank you very
Okay,
much.
thank you.
I'm just going back to the testimony that we had, that the bill proposes expedited court processes mandating the issuance of summons and decision-making within specific timeframes. So I think that that's really the strength of the bill, because when you talk about the enforcement of parenting plans, and we had a lot of bills that were filed concerning these parenting plans, and we did hear on other bills a lot of other testimony as well. This amendment, I think, improves that based on the testimony that we did have. And I'm going to turn it over to Mr. Lehman on this particular amendment.
All the amendment does is add a materiality requirement to the language concerning there being a breach or noncompliance with the plan. So the idea being that a court shouldn't be taking action or even asked to take action for minor in things that aren't really of substance to warrant that kind of judicial interference. Like if somebody's 15 minutes late delivering a child to a change of custody location, or sort of minor things shouldn't be given priority on the court docket.
Okay, does it? Senator Chanley, do you have a question?
I think I may.
We have a 2-minute recess.
Sure.
Thank you.
Okay, we'll be in recess for 2 minutes. Okay.
So,
All right, hold on. Okay. Okay, here we go. The committee will come out of recess. We're still discussing amendment number 1603S to House Bill 1006. We've got a proposal to, on line 3, section 1, to change material to substantial. Okay. Who wants to discuss?
Yeah, I think I'll let Senator Chanley also weigh in that the term material didn't quite, I understand the intent of that term, but it didn't quite fit with the standard that we were trying to, I think, policy-wise achieve.
and thank you. I would say the same. And that was, with the question I was sort of toying with. I do think that the amendment improves the bill, and I can go along with the bill. I want to make sure that as we are looking at this, we are not allowing for issues that are not significant, that aren't relevant and significant to the parenting plan and that don't reveal any intent to disrupt the parenting plan, that those don't get sent to court. And so I'm happy to hear others' thoughts on the language.
Senator Abbas?
Just a question. So material versus substantial, like when it comes to the application of that, are we raising the bar, lowering the bar, I guess, and how much are we raising in or lowering the bar?
So, if Aaron doesn't mind coming up and discussing that, like, because the reality is it's how the courts are going to interpret it. And so I think it's relevant to hear from the court system about how they would interpret those different terms and what they actually mean to the court system. Do you see what I'm asking? Okay.
Yes, ma'am. Erin Cregan, General Counsel, Judicial Branch. Doing my best for my clients to kind of give advice on their behalf on what is potentially helpful to them. Materiality is typically a relevancy determination. So you have whether a fact is material is whether it relates to the inquiry, or whether a breach is material is whether it goes to the core of the agreement. That doesn't mean that if a judge sees this term, they won't understand that it is a gatekeeping term, that is intended to apply a standard. I think it's clear what the legislature's intention is. But judges also agonize over every little word that you use and want to make sure that they are doing exactly what you want. You could theoretically use a scale term, and that might be more likely to convey what you want, depending on what you want. Significant, substantial, egregious is a very high standard that you would not want many of these motions to succeed, only if they're really a very big breach. So there are scale words that you could use that the judges would cue off of and have a general understanding of the gatekeeping function that you want this term to play.
So follow-up question?
Yes.
So substantial is more of a scale term, whereas material is more of a relevancy term.
Yes, but of course, no code is completely consistent on any one term. You will probably find the term used in slightly different places in different areas. But if you look at like a Black's Law definition of materiality, it will typically be a closeness determination rather than a scale determination.
So I guess, Senator Carson, is the intention of the amendment, what's the intention of the amendment then? Maybe Senator Abbas, you had a...
So I guess, so material, I think of like a contract, right?
Right.
A technical breach.
Right.
The money came in, 5 minutes after whatever deadline. That can be considered material by some, but sometimes it's technical. No.
And the term is certainly litigated in the contract context all of the time, but the general understanding it is the core terms of the contract, right? That is that which constituted the basis of the agreement. So you could take this term in the parenting plan and say, what was the most important to the parties in this parenting plan? But it's maybe not what you're intending to convey, like a contract situation.
So substantial, I guess, we're not really, I'm just trying to think, is there a definition of substantial that's floating around under existing law?
No, I mean, I think you see the term in other statutes, and it's really just the plain meanings of terms.
I look at this as, all right, someone's 20 minutes late to drop off or pick up with the children. There can be a lot of controlling factors that relate to that. They may be stuck in a hearing. They may be, who knows what's going on. So, which happens. That's really, to me, not a substantial breach. I mean, if it happens if it keeps happening, maybe you can make that argument. I think I'm more concerned when the parent doesn't show up, period. But, and that goes both ways. Even if there is their parent time, don't show up. The other parent may have schedule obligations when they don't think they're gonna have the children. And all of a sudden they're here, and sometimes the schedules are made for a reason. So I think that would be substantial, but I guess without any measurement of that, obviously just not dropping off at all.
And I'm certainly not trying to complicate your analysis. Sometimes you can have examples in a statute, and that can be helpful to the court of what you would not consider to be a substantial, significant, or material breach. But the courts, I think the major policy objective here, which is to have something that makes sure that minor infractions are not covered, is covered with the word material, but it may not be as indicative as you would want.
And I think if, Madam Chair, if someone were to file one of these, let's say, and it was more technical, even if it was substantial, there's no real remedy for you anyway, because didn't really amount to much. You lost 20 minutes of your parenting time.
Well, I have a suggestion. Why don't we use both? Can we do, is it substantial and material or substantial or material?
Yeah, sounds good.
Not that I like to compare it to other states, but I know other states use, like, for modifications, substantial and material.
Okay, well, there we go. Okay, so Matthew, we're going to have a committee amendment to House Bill 1006 on line 3. It will read, in the event of substantial and material noncompliance, and then the rest of it will be the same. Is there a motion for that committee amendment?
I will move that.
Moved by Senator Chandler, seconded by Senator Whitley. Is there any further discussion on the committee amendment? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar?
Or do we have to vote on the whole bill?
Oh, that's right, I'm sorry. We've got to do ought to pass as amended. Is there,
I think you made the motion.
I made the motion, so Senator Gannon seconded. Okay. Is there any further discussion on the bill as amended? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any noes?
Consent?
Okay. Is there a consent calendar motion?
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? No? Okay. Who wants to take this one out?
Senator Abbott definitely wants to take it out.
All right.
I will take it out if you want.
Well, you didn't help me on that reconsideration.
Senator Chandler offered to take it out. So is that okay, Senator Abbott? Or do you want to take it out?
No, please.
All right, you guys decide.
I don't mind taking it out.
Okay, all
I
right.
think it's a very good policy, and I'm glad we were able to.
Okay, there you go. We're done. Okay, next we have House Bill 1012. I'd like to move interim study.
Second.
Okay, this one, the prime sponsor was not available. She did send us an email explaining the bill, but we had no testimony presented whatsoever on this bill. We just had people that signed up in support and people who signed up opposed to the bill. I kind of understand where they're going with this, but I think it needs more work, it needs more definition. So that's why I've moved interim study. Are there any more comments? Senator Abbott, did you have a comment?
I'll say that I think this is well intended, but I think what they're trying to cover is already covered under the existing law. And I think in that case, it has to result in endangerment of the child. Just because a child's in an endangered situation doesn't mean the parent was negligent or did something wrong. But this is kind of taking a carve out of what is or is not endangerment. But I think should be circumstantial.
And quite frankly, I think too that there should be some sort of differentiation for different age groups. An 8-year-old out playing by themselves is very different than a 2.5 or 3-year-old toddler walking the streets. I mean, very, very different. So that's why I said I think this bill needs some more work, and that's why I've moved interim study.
An example I can just apply to myself, right? We live on a lake, right? Now it's fenced up and all, but we tend to still not let the kids roam around the backyard unattended. And to me, just letting them go in the backyard, they say, oh, it's my property. I get all that, but circumstantial wise, there's, a large body of water sitting right there.
Okay, so we have interim study. It's been moved and seconded. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Consent?
Senator Whitley moves consent. Is there a second?
Second.
Second by Senator Chandler. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Senator Gannon, you do this one? Okay. Okay, next we have, House Bill 1104. I'd like to move on to pass, seconded by Senator Gannon. I think this, is well done. It establishes procedures and standards for the review and decisions made by judges found to have committed judicial misconduct by the Judicial Conduct Committee. Is there any discussion? Senator Chandler? You're kind of like, I'm not sure.
I don't know. I'm not opposed to this, and I can, but I did, I was understanding of some of the testimony in opposition. I guess the only question I have, I think, was answered regarding, came from the Special Committee on Family Court. All right, okay, I'm fine.
Okay. I think really most of the feedback that we had was people didn't feel the 3-year look back was long enough. 3 years is a good place to start. If that works out well and people want to go further beyond, that's fine. But I think this is a good to move. Abbas.
I understand the look back period, but a lot of misconduct type of things that can be somewhat ongoing. So it's usually not just an open and shut thing. I mean, and if it's one decision they're talking about, I mean, that it's egregious, it should be dealt with right away. No explanation why you wait more than 3 years.
I just think it's important to note it's 3 years after the date of the ruling, not 3 years after the date of the thing that caused somebody to get irritated with the judge. So it could be 10 years in the past if the ruling only comes up. I mean, it's like a statute of limitations. When you become aware, you generally have 3 years to raise your concerns. And so it doesn't really block off things that happened a long time ago. It's timed on the Judicial Conduct Committee's decision-making process.
Okay. So we have an ought to pass motion that's been moved and seconded. Is there any further discussion? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there consent calendar motion? Moved by Senator Whitley.
Second.
Second by Senator Chandler. Is there any discussion on the consent calendar motion? Okay. Seeing none, all in favor say aye. Any opposed? Okay. Who would like to take this one? Anybody in particular? Yeah, I'll do it. Okay. All right. We're gonna hold House Bill 1192. We've had a request to hold that one. Next, we have House Bill 1214, which seeks to establish a committee to study best practices for the development of a restorative justice model for misdemeanor level behavior and hate crimes committed by juveniles under the age of 18. I'd like to move ought to pass.
Second.
Seconded by Senator Whitley. Is there any discussion? It's just a committee. And it's worth looking into. So, okay, we have the ought to pass motion. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. move consent. Is there
Second.
second by Senator Chandler? Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, who'd like to do this one?
I'll take this.
Okay. Okay. Next we have House Bill 1220. I'd like to move ought to pass.
Second?
Seconded by Senator Whitley. We do have an amendment because we had a public hearing on amendment number 1590.
Yep.
Okay, and I'd like to move ought to pass on that amendment.
Second?
Seconded by Senator Whitley. I think this is the amendment that was not presented at the public hearing. This is the amendment that represents the agreement because we had, the Secretary of State came in, but there were also some, the BIA had some concerns, as well as another industry that had some concerns. They met, they've come to an agreement, and that agreement is reflected in this amendment.
Yeah.
So we have an ought to pass motion on amendment number 1590S. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, we have an ought to pass motion on the bill. Is there, and we've got it seconded. So we have a motion of ought to pass as amended. Is there any further discussion on the ought to pass as amended motion? Yep. Yes. Yes, that is the new one. Okay, so is there any further questions, comments? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay.
Consent?
Senator Whitley moves consent, seconded by Senator Chandler. Is there any further discussion on House Bill 1220 as amended? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, who would like to take this one?
I'll take that.
Okay, Senator Whitley will take this one. Okay, next we have House Bill 1270, which is relative to protective custody statutes. I'd like to move ought to pass, seconded by Senator Gannon. This one was kind of interesting. I didn't know that they locked you up for being drunk. I thought they just, charged you and then called somebody to come and get you. So this basically repeals the requirements imposed on local jails and county correctional facilities. Is there any further discussion on the ought to pass motion?
Didn't you watch Mayberry?
Yeah, but that was from the early 1960s. Okay.
And any concerns that if someone's too intoxicated to be released, then they'll be brought to the hospital, not to.
Yeah.
Yeah, that's
I
what
don't think that we're just gonna let someone wander off.
Yeah, they're not gonna
They don't
let
care.
somebody, and they just call somebody, come and get them. So, and if they can't find anybody, that's where they keep them. But I think it had to do with the requirement that they test them and so on and so forth. So, okay, so we have an ought to pass motion. Is there any discussion on the further discussion on the ought to pass motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Consent?
Okay, Senator Whitley moves consent. Is there any discussion on the consent? Seconded by Senator Chandler. Okay, we have a consent calendar motion. All in favor say aye.
Aye.
Aye. Any opposed? Okay, who would like to take this one up? Senator Gannon, okay. Okay, next we have House Bill 1276. I move interim study.
Second.
Okay. We had this one last year. We ITL'd it, I believe. The sponsor came back this year and said, I listened to you and we've made it so it can't apply to minors. I think I know where the votes are. Is there any discussion on this issue? Senator Abbas?
I'm just gonna say a little bit of a delay. So, in order to possess one of these, all you need is a fishing license or a hunting license. Right now, when I get my fishing license, I just do it online. That's it. So I'm wondering, what's this license requirement really doing here? These are, I mean, there's other things, I know metallic brass knuckles, they have that, people know what those are, but they sell other items that are very similar that are not illegal, that fall outside of this. So we're not really preventing someone from putting something or attaching to their hands that they can strike someone. And you can buy gloves right now that have like that, like the plastic for some of those water bottles that they sell built into the gloves. Those are actually, to me, worse than brass knuckles because you also can get through a metal detector with them. So you can walk into a courthouse with them and go relatively undetected. With that being said, you don't need a license for those. But I don't see like how the fishing license relates to brass knuckles. I understand that some of these can be used for fishing or hunting per. I get that. To me, I'm not sure the requirement. I think the issue of the age that came up last term, this addresses that. So,
It is.
so I would sort of impose an interim study and hope we can join me and not the pass.
Okay. So we have a motion of interim study. Is there any further discussion on the interim study motion? Seeing none, all in favor say aye. Aye. Opposed? Okay. Senator Gannon? Okay, we'll do this one. Okay. I think we have two more. House Bill 1341, which is relative to the liability of grandparents to provide assistance. I think this is a horribly outdated law, and we just need to take it off the books. And basically that is what we heard. There was a review of the New Hampshire Child Support Guidelines, and it was recommended that this bill be repealed.
I'll move on to pass.
I'll second.
Okay, to pass. I thought we did that. Okay. So we have a motion about to pass, and it's been seconded. Is there any further discussion on the ought to pass motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, consent calendar motion has been moved and seconded by Senator Whitley and Senator Chandler. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, who would like to take this one out? Who, you want,
What about
okay, Chandler?
Simon?
Okay. Okay, and the last one we are doing today is House Bill 1659. I'd like to move interim study, seconded by Senator Whitley. Again, this is one of those, we got a lot of the shared parenting bills this time, and I think it's because of the House Special Committee that they put together. But there's some issues here that just need to be resolved that are not. We did receive testimony against this from New Hampshire family law attorney. And we did get a copy of the ACEs, the Adverse Childhood Experience. I just think this is not ready to come forward at this particular time. I think it does need some more work. And so that's why I'm moving interim study.
Just to
Senator Abbas.
Just to clarify, I think the problem is with this, it's too broad, it may catch more than we would want it to.
Mhm.
But I think a narrower version of this would make sense because there are circumstances where a parent will not have their parenting time when there's a DCF investigation.
Mhm.
And if they come back and conclude there's been no neglect or no finding of abuse, that parent time can be lost. So say that the parent has been estranged from their children for 6 weeks. And this kind of offers them a situation where they can kind of make up some of that time.
Mhm.
I think there's issues of domestic violence cases where we don't really want to catch all those, but the finding by DCF is a much lower standard, so
Mhm.
maybe we keep an open mind to this in the future, but not.
it also, it says that both parents shall have access to all records and information pertaining to the child. That I think can be problematic at times too. So that's why I think the basic idea here is good, but I think I agree with you, it's overly broad. The courts are the ones that hear both sides of these issues. When we have people come in, we're only hearing one side. And I'd rather have the court have the flexibility to make those decisions rather than us mandating it.
In that section, I think parents are, that's essentially what legal custody is, not
Right.
physical. So you have legal custody unless, if the court says you have legal custody, they can
Right.
maybe restrict one of these, but once you have legal custody, you already have access to that,
Right.
unless there's an order taking it away.
Yeah, and plus, there's a $500 fine for, you brought the kid back 5 minutes late or 10 minutes late or something. I mean, I just think that it's way too broad. And I agree, it's too wide a net, and you're gonna get people caught up with it, or you're gonna have people that are gonna abuse it, one or the other. It's just not ready to come forward. Is there any further discussion on this? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Senator Whitley moves consent.
Second.
Seconded by Senator Gannon. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, I'll take this one up, Matthew. Okay. Can I, just before we've done, the bills we were gonna do today, just to, remind everybody, we're here tomorrow. We have a full day of hearings. So I look forward to seeing you all tomorrow. Pardon? We're in at 9, and we're gonna go until we finish. After we conclude tomorrow's hearings, all our fiscal note bills will be done. So what I'm looking at is, again, we are going to be here next Tuesday, the 30th. We will hear, I believe, 7 bills that day. That will be the only day we're meeting that week. And the following week, on the 7th, we will hear the final 4 bills that we have assigned to our committee. If we can, we might do a little execing, but I'm going to take the afternoon of the 8th, and we will exec the rest of our fiscal note bills because they have to be out of committee on the 9th. And on the 14th, we'll just exec. Okay? So that's the schedule kind of going forward. And I want to thank all of you because that means we will have moved 61 bills since March. So again, can I get a motion to come out of executive session?
So moved.
Moved by Senator Chandler. All in favor say aye.
Aye.
Aye. Any opposed? Okay. Thank you all very much.